Hi, good evening, everyone. Suki here. Hope you all had a good day.
Good evening, Suki.
Hey, good evening. All right, let's give others a couple of minutes and we will get started. I might wind up a little early today because I got to go to some place. I'm sorry. Yeah, so we will usually close around 8:30, but I mean, sorry, 10 India time, 8:30 my time. But today we may close 10 minutes early at least. Okay, while we wait for others, can anybody do a quick recap of me of the history line that we were following yesterday?
Yes, okay, I can do it. Asta here.
Yes, Asta.
Yeah. So, firstly, because we had Universal Declaration of Human Rights, which came into force on 10th of December in 1948 to protect our basic human rights such as dignity and freedom, and that included freedom to personal life and liberty, and freedom to expression, and freedom to private life. So these were
Mhm.
basic human rights. Then this was 1940s. Then in 1950s,
Do you remember the article numbers?
it was Article 12, that was freedom to have private life and personal affairs, and Article 19 was
Right
freedom of
to freedom
expression.
of speech and expression. Yeah.
Very good. Now, what was Article 29 to under
Yeah, that
UDH?
that said that no right is absolute, and it can
Hmm.
be
Very
it
good.
can
Okay.
have restrictions if there is any controversy in
Very
terms
good.
of rights.
Okay, let's move on.
Yeah, then in 1950s we had to incorporate Universal Declaration of Human Rights. So Europe enforced European Convention of Human Rights, that was known as ECHR. So
Mm-hmm.
that came into force on September, I think 2nd or 3rd of September 1953. Then
Mm-hmm.
it was here there were in UDHR there were Article 12 and 19. In ECHR those articles were um, 8 and 10, if I'm not wrong.
Similar articles were 8 and 10.
Yeah, 8 and 10. I
Yeah.
don't remember that article corresponding to Article 29, Clause 2 of UDHR.
That wasn't covered
Oh, that
under the.
wasn't covered. All right. Yeah. So that was the
Which
European
body
Convention of
which body enforces European
uh,
Convention on Human Rights?
European Court on Human Rights.
European Court of Human Rights,
Court of
and
Human
that's
Rights.
located in Strasbourg,
Strasbourg,
right?
yeah.
Very good. Okay.
Then this was 1950s. Then there were various countries that were coming up with their own legislations on privacy,
Not
data
privacy,
privacy
data protection.
regulations. So then in
Data.
9 yeah, on data privacy and the respective regulations. So then in 1960s there were three countries, namely Austria, Portugal, and Spain, which incorporated data privacy as their fundamental right in their constitution.
Mm-hmm.
Then in 1970s we had then in 1960 only there were recommendation 509. So that captured
No, 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 no.
no, there is something
Okay.
missing.
1960s, yeah.
I think it was 1960 only. Then 19 recommend
1968.
right?
1968, right?
19 right,
Yeah.
yeah, 1968. So then there were recommendation 509. So that basically covered the gap due to the upcoming technologies that were there. Then we had resolution 73 and 74 for a regulation on data privacy in private and public sectors respectively. Then after that we
The
had
resolution were nothing but they implemented the recommendations given by 509.
okay, all right.
Oh, yeah.
Then after these, we had OECD guidelines, no, Organization of Economic um, Control
Yeah,
and
Organization for Economic Cooperation and Development.
Cooperation and Development, OECD guidelines. So they came up, and this was made like OECD was not only restricted to Europe countries, but there were countries other than Europe as well, European countries as well. So this was to bring in. This was not exactly related to data privacy, but this was to bring in more economic growth among the member states. So it also had these guidelines and principles. So we discussed these 8 principles of OECD yesterday. So there were purpose, purpose limitation, purpose specification, use limitation. Uh, then we had individuals' participation, then openness principle, then accountability and and security and safeguards, and there's I'm missing one principle.
Equality.
Yeah, quality. So we discussed these principles in detail yesterday.
All right. So we thank you, Asta. This is very comprehensively you covered. Thank you very much. So we stopped with a question of or a takeaway as an activity for us, right? To think of any question that one may have in mind that they would like to get clarified before they disclose their personal information to a body or an organization which is asking their personal information, which potentially you think is not going to be fitting under the OECD principles. So anybody had thought about this? Any scenarios that you want to discuss? That hey, I want this principle to be covered before I could hand over my data to data controllers and processors, but that's missing in OECD.
Legal it is, Suki.
Can you explain that further? Hello. Sorry, I lost you. I mean, is it my connection, your connection? I think I lost you.
We can hear you.
All right. Okay, we'll wait for that person to come back online then. Anybody else?
Harish, yeah.
Sorry?
Somebody's echoing. Hello?
Yeah.
Yeah. Also, this is Harish, yeah. If I'm giving data to a real person, as in not through a web application, I'm giving data to a real person, then I might want to know what kind of authorization they have to collect data.
What kind of?
I mean, are they authorized to collect my data? I mean, like, do they have the authority to collect my personal data?
That's part of openness, isn't it?
Okay.
Yeah.
Suki, where do you fit transparency?
Openness.
Okay. And lawful processing?
Again, openness.
How about discrimination? Does that fit into any of these principles? Like, my data is processed without discriminating. Like
Purpose specification.
Okay. But does purpose specification not talk about only, why are they collecting the data?
That's right. Why are they collecting and how will they use it, right? So that's what purpose specification and use limitation put together. Don't you think there is an indirect ask of these players to disclose that they're going to be automatically profiling you or anything like that?
Okay. And I have one more. So let's say
Sorry, speaking. Can you introduce yourself?
Hello.
Can you introduce yourself? Who's speaking?
This is Vani.
Hi, Vani. Okay, fine. Yeah, thanks.
Okay. So does enforcement come under accountability?
Enforcement of what?
Like, let's say I have a complaint we discussed about who's accountable, yes, but can that be enforced, on the person who's taking my data?
Okay, so enforceability, uh, fine. So I see this as part of many principles here, right? So openness will anyway talk about what are the legal remedies that people have if they find their data to be processed in an unlawful fashion. So that anyway covered and is covered in the openness requirement. Accountability also speaks about having the right protocols and procedures and policies internally to cater to these, enforcement requests. Tomorrow, let's say if the ICO office is coming and doing an investigation of a company, then they should be able to respond to that investigation request altogether. So, in a way or the other, openness will speak about openness as well as individual participation put together will speak about the enforceability of the regulation on the controllers, and if they fail to meet certain obligations under the law, what remedial actions that one has to be communicated, part of openness. And in many cases it is also a right. So today under GDPR, people have a right to lodge a complaint with the supervisory authority, so that comes under individual participation. And accountability, of course, will complement that by having, but or by mandating the organization to have the right protocols around responding to enforcement purposes.
Okay, yeah, I get it.
Suki, Niranjan here.
Hi,
Yeah.
Suki.
Uh, shall I ask the question?
Yeah, please.
Go on. Yeah, please.
Yeah. Okay. So which principle talks about data retention period?
Mm-mm. Which one? In your wildest guess, tell me.
Openness.
Everything have to openness because all of those information has to be put in front of the consumer. But apart
No,
from openness, I think that
I
will also
feel I feel security safeguards.
correct. Yeah, security safeguards covers retention requirements as well.
Okay.
A quick
When we
word.
also speak about use limitation indirectly also means storage limitation. That means you can
Correct.
store and use the data only for limited activities and limited periods. So use limitation may also have an overlap with data retention requirements.
Okay. Thank you.
Yeah.
Hi, Suki. Pritish here.
Happy.
Just wanted to know if accuracy is getting covered under any of the principle, or if it is
Data
getting covered
quality.
under.
Data quality is nothing but
Data
accuracy.
quality comes under, yes.
All right.
All right, very good. So, anything else?
Just one more thing. This is Harish here again. Like the medium through which they're collecting my data. So where does this come under? Like as in like, are they collecting through mail, a phone, or through a form, or actually physically in person, or something like that?
Why do you need that? I mean,
I mean,
you are
it,
reading medium, right? Does that
for
has
instance,
to be said somewhere?
not no. For instance, say they're asking about my financial data, credit card data. I wouldn't give it through phone. I would like to verify maybe a mail or in person. And so that's the reason I'm asking. So does it come under this category? Or like, I mean, is it like an important factor, right? No.
Let me think of this, right? So if somebody reaches out to you and then they say that I want your credit card information, can you go give it over the phone?
I mean, like, it could be anything. It could be a social security number or any confidential data.
No, I don't think it explicitly says something about these are the any law for that matter, right? So it will not go, or the principle will not go that and say that these are the data elements that you can only collect through a specific channel, right? That kind of granularity that if you're looking at, it's not going to be available. But in general, when we speak of collection limitation, it is not just about data that is getting collected, but also the medium through which data can be collected.
Okay.
Yeah.
So it'll mostly come under the I mean,
The
like, I mean,
collection
which
limit.
collection limitation? Okay.
Yeah.
Okay. Thank you.
What else?
Suki, I wanted to know, this is Gerald here.
Yes.
Uh, does any control, or the how do you call them? The people who retain your controllers, right?
The controllers and processors, right? Yeah.
Yeah. So, do they anytime have linkages to other people? Like, say, they're collecting individual information about me, but do they also try and relate it to with another person, like with the family or the organization or anything? And is data stored in any of those forms? I would like to know if they do, or if there is any of those principles that is taking care of that.
That should ideally said as part of your collection limitation, purpose specification, use limitation, openness, all of them covered, right? So end of the day, what we're looking at, primarily openness principle. It would require the organizations to put it straight in front of the customer, saying that these are the data that we collect, and these are the various medium through which the data is going to come. When I say medium, it's not like the channels, but let's say if you typically look at WhatsApp's privacy policy or Facebook's privacy policy, it'll have multiple sections. It'll say information that you submit to them while you create your account, information that they automatically capture from your mobile devices, like the IMEI number, which network that you are tagged to, the details of your sensors, geolocations, access to your media, access to your call logs and other stuff. So these are information that you may not be explicitly giving away to WhatsApp, but it is automatically captured from your devices. There's also a possibility that they may do a scan. For example, if you take Truecaller, which is one of the weirdest apps from a privacy standpoint, right? So, the whole model of Truecaller is correlation. So you may have somebody's number stored as one name and somebody else has got the same number in a different name. So they kind of identify that individual from multiple sources and have a common record created. Now, all of these data that you're talking about, the points through which you collect, you derive data, you kind of, uncover or profile people using the data that you're deriving, it all has to be explicitly told as part of openness principle, as part of collection limitation principle. So why would you need that data explicitly? If you are not collecting as such, but creating also, you have to inform about that to the individuals. Of course, you have to also mention the purpose, why you want that specific data. So all of these principles in a way or the other touches them, but a very good question. Thank you for asking that.
Yeah. So basically, if I make an understanding that they are able to make some kind of a correlation about my data with another member in my family or a friend, can I go and ask them not to make that kind of linkages, or is there any option for that?
Under the GDPR, if you look at, can you say that don't link my data with anybody else's? That explicitly is not option for you, as long as the business reason why they have collected the data from you is that legitimate thing, right? But let's say if they are using the data to profile you, to kind of understand your characteristics and put you under a specific bucket for targeting, and then they do any sort of automated decisions on top of that data using algorithms, then you have a right to say that I don't want to be subjected to be profiled. Also, I don't want it to be subjected to, or not subjected to, but you have a right to stand against an automated decision that was taken on you using your data, and ask for a human intervention in those cases, right? So those rights you definitely have. Blanket, you cannot say that I don't want my data to be linked with other family members and other thing, unless otherwise you can prove that you're being profiled and other thing. Otherwise, generally, this linking and other activities that can potentially happen on your data becomes unlawful if they have not disclosed explicitly why would they need that, right? And if you think that the reason that they're giving, why would they need your data to be tagged along with your family members' data, and you are unsatisfied, you have an option not to give them the data at all.
Sure. Okay. Yeah. Thanks.
Thank you. All right, so very good discussion, 20 minutes or so. But you can very clearly see the 8 principles of OECD kind of clearly touches all of the questions that you may have in your mind when disclosing, or what you expect out of an organization will all be fulfilled if the organization in its spirit follows all these 8 principles, right? Now, that is why OECD has been the very fabric of most privacy regulations across the world. They have inherited a lot, all of these laws that exist today and regulations that exist today, frameworks that exist today, have inherited a lot of common properties from these 8 principles. Rightly said, the Convention 108, which is the Council of Europe's version of the OECD, which was again co-developed along with OECD, right? So this is also going to be talking about the same flavors, same principles in itself. So Convention 108, this is a very, very important landmark in Europe's data protection history, because of the reason that this is the first legally binding instrument in the field of data protection, right? So what did Convention 108 again did was a very interesting thing. So you remember those 2 resolutions that were passed in 1973 and 74 about the missing elements in ECHR's thing on fundamental rights and human rights, the technological advancements. So those resolutions, which were giving a good proof that that resolution was only limited to the parties which were signing that resolution. Now with Convention 108 coming in, it did nothing but kind of reaffirmed the resolutions that were passed in 1973 and 74. That's what precisely Convention 108 did, right? So all the parties which were signatories to this Convention 108, they were required to take necessary steps within their countries and come up with a domestic legislation that will ensure the principles of Convention 108, which is very, very similar to that of the OECD principles, are implemented within those countries and backed properly by a legislation, so that it is going to give some amount of commonality between many countries that are part of the Council of the Europe, right? So if, let's say, there are 25 countries, there were 25 countries at the time of the signature of Convention 108. Each of these 25 countries, Convention 108 is going to be legally binding. That means they will have to enact a data protection law within their country, which kinds of resonates the same principles of OECD and Convention 108. And that is the very first step towards harmonizing an approach towards data protection across multiple countries in the European Union, so that the pain of cross-border data transfer is reduced to a great extent. Like, today, data from Spain to Portugal, if Spain is party to Convention 108 and Portugal is also party to Convention 108, then I can have some confidence, since both of them have signed this convention, they will have many commonalities in terms of the principles on which the data protection law is formulated between both countries. My concerns initially that were there when, let's say I can have a data protection law in Spain in my own, according to my own whims and fancies, and I can have a data protection law in Portugal according to my own whims and fancies here, and absolutely no compatibility earlier. That absolutely no compatibility factor is now gone, with some standardization being put by both the parties signing the convention, is the major first step towards harmonization. Right? So that's the benefit of Convention 108. You can for sure expect a question in your examination on Convention 108. Most of the times it's going to be about which is the very first legally binding instrument in the field of data protection within the Europe. That's going to be the question, where you may be having multiple options like Treaty of Lisbon, ECHR, Convention 108, and Treaty on the Functioning of the European Union. So these are the answers. Now you have to choose Convention 108 as the answer. So you can for sure expect a question in that space, right? Convention, similar to convention, the OECD principles, where OECD had, OECD guidelines, where OECD guidelines were 5 parts: general definitions, basic principles at national level, international application. Then what else we had? National implementation and international cooperation. Similar to that, Convention 108 had also 5 chapters within it: basic principles for data protection, cross-border data flows, mutual assistance, and consultative committee. So you can directly map each one of them back to this. Basic principle for data protection is the equivalence of basic principles for national application in OECD. Trans-border data flow is the equivalent of Part 3 in OECD, which talks about free flow and legitimate restrictions. Part 4, mutual assistance, is nothing but the international cooperation here in OECD. Part 5, consultative committee, is also part of the national implementation of the cooperation, international cooperation in OECD, right? So the chapter 2, as here, part 2 was the expanded to include these 8 principles. In this case, it was chapter 2 that got expanded into the various principles of privacy or data protection under Convention 108. The various different articles of chapter 2 is duties of the party, quality of data, that is nothing but your data quality principle. Special categories of data is another thing which was introduced in Europe, because certain data which can be discriminatory in nature, they wanted to have additional protection towards it. Data security, mappable again. Additional safeguards for the data subject, mappable again to the individual participation. Exception and restriction, sanctions and penalties, extended protection. So these are the various topics that the Convention 108 chapter 2 was speaking. Chapter 3 was speaking about trans-border data flows. Chapter 4 about mutual assistance and consultative committee. The bottom part, this section that you see here in my screen, let me point. Oh, sorry. This is something that is not required for examination, and I just gave as an additional information. But this first bullets were the one that you might be interested in looking from an examination standpoint. So this is how Convention 108 came in. Remember, Convention 108 was adopted on 28th of January 1981. So 81 year is enough. 80 is OECD, 81 is Convention 108. And the most important aspect that you have to remember is the legal binding mechanism of Convention 108. Now let's quickly go for some quiz to break ice.
Can I ask a question?
Please.
So, as you told, that this is the first legally binding international instrument, right? And the member states were required to take necessary steps to apply those principles.
Right.
So, if any member state did not take any necessary step to apply those principles, so automatically the principles that were already enlisted in this convention were applicable to that member state.
Yeah.
So okay.
Due
So
to the international binding nature of it.
Sorry, Suki?
Due to the international binding nature of it, at least whoever is signing to it, they will have to implement this. If they have not implemented it, the other parties involved can take remedial actions against them using the international arbitration or internationally available modes of remedial actions, including they can go to the Court of Justice of the European Union or some other mechanism through which they can pursue these countries to take remedial actions.
Okay, Suki. Thank you. Got it.
Yeah. All right, the first question for you guys: which of the following is /R considered as the rationale for data protection? Rise in information sharing, advancements of information and communication technologies, large enterprises setting up large data banks, international data transfers.
All of them.
First one.
All
of
of these
them.
look. All of these should be the answer.
All right. Any other thought processes? Anybody who differs from all of them? All right. All of them is the right answer. Great. Which of the following is the first legally binding mechanism on data protection in Europe? Just discussed.
Convention
Convention
108. 108.
Okay. Let's take a look at the others. Recommendation 509. What was that?
That was brought in 1968, right after ECHR.
That's just a recommendation. It's
Right. What's the recommendation on? What do you remember about it? What did it recommend?
Technology requirements.
Yeah, that was to fill the gap that were not assessed in the ECHR regarding the advancement of technologies.
Very good. Okay. What about OECD guidelines? Why OECD is not a legally binding mechanism?
It was not, it was just to assist the member countries as to how they could increase their economic growth, and if not, and at the same time also protect the privacy of individuals with regard to their data. So it was not legally binding.
It's just a guideline.
Right.
The implementation is left to the organizations or the countries. European Convention on Human Rights is like, it talks about human rights. It's not legally, I mean, it is also legally binding, but it is not specific to data protection in the European Union, right? So remember, ECHR is also a legally binding mechanism. It's not like it's non-binding. ECHR is legally binding on all those countries which were party to the convention. But the only reason why ECHR is not the right answer is because the question is more specifically on data protection. The question was specific on human rights. Your answer should have been ECHR. All right. All right, let's go to the next one. Which of the following OECD principle states personal data should not be disclosed, made available, or otherwise used for purposes other than those specified?
Use limitation.
Use limitation.
Purpose specification.
Okay, how many votes for use limitation? How many for purpose specification? Let's go on a vote.
It's actually confusing. I think it's
Read the
purpose.
statement once again and confirm me, please.
Purpose specification.
Purpose specification.
Use limitation also.
Use limitation.
The answer is use limitation. It is not purpose specification. Purpose specification, we are saying that tell the purposes for why you are collecting the data. Use limitation is where we are saying don't use the data for anything other than the purpose that you specified. Look at the language here. Otherwise used for purposes other than those specified. So whatever you've told them already, don't use the data for anything else that you've not told them. That's the statement here. Personal data should not be disclosed, made available, or otherwise used for purposes other than those specified, which is nothing but use limitation. So read the words carefully and then answer this question.
Suki, why not
So
purpose specification? Can you explain again?
What do we say in purpose specification? We are asking organization to tell users the purpose for which data is being collected.
Okay. We're just asking them to specify the purpose. All right.
Whereas when we speak about using the data for any purposes, then it becomes use limitation.
Yes, okay.
All right, let's go further. Individual rights are not absolute. True or false?
True.
Why do we say it is true?
Because of Article 29, Clause 2 of
29 2.
UDHR.
Very good. Which body enforces the European Convention on Human Rights?
European
Codes of Human Rights.
Very good. What does European Economic Community does? What an utter silence.
Trade between the EEA countries.
So European Economic Community was the precursor to the European Union. So before European Union was formed, they were acting together as an economic community that was EEC. So EEC was formed by few major players in the area of steel, something else. Some other companies were the drivers of European Economic Community. I keep forgetting that, right? Okay, fine. So that's about the quiz. Let's go on to the topic, but I'll do a quick time check. Okay, we have 10 more minutes for my break. Okay, fine. So let's go on. Now, okay, with Convention 108, we started to speak about a little bit of an harmonization, right? So before that, everybody had, excuse me, everybody had their own laws, which may or may not be compatible with the other member state regulations. I think somebody is not on mute. I would recommend them to go on mute, please. Thank you. So with a very, very slight harmonization in place, Europe was like, looking at avenues and how do I increase this harmony of and have a common approach for data protection across the Europe. That was their next goal to look at, right? And that's when they started to think of between 1981 and 1995, there was nothing. It was left to the individual countries to follow their own legislation that they have created. And that was the fundamentals of data protection in those countries. But in 1995, again, European Council or the Council of Europe reconvened and then said, let's take this harmonization to the next level. And that's when they came up with the idea of data protection directive.
So sorry to interrupt you. I just need to ask one thing, that this convention 108, was it limited to EU member countries or whole Europe?
It was limited to EU member countries.
Okay.
Yeah. So this next step towards harmonization started in 1995 with this data protection directive, otherwise called as DPD 1995. The directive's number was 95/46/EC, right? The European Commission's adopted directive this is. So this was the first step towards a larger harmonization from the Convention 108. Now this also had, a few setbacks from a complete harmonization, because this being a directive, not a regulation. Okay, fine. Let me ask this question. What do you think is the difference between a directive and a regulation?
Vani here.
Regulation has to be accepted and passed by the individual member countries, I believe, and directive is directly binding on the countries.
No, you just made it ulta.
Okay.
Directive is basically like a guideline. You're just giving the directions to the member states to make their own rules. But regulation is like a law which everybody has to follow.
Correct, right? So the difference between a directive and a regulation is this. Regulation, you don't have a lot of leeway to play around it. You just have to follow it as is in many times, with whatever caveats that have been given for playing around. But a directive, unlike, is also kind of a regulation, but not as stringent as a regulation. The reason is, it will say what are the principles that you have to adopt. It will say what things you have to put in place. But the choice of implementation, the method through which I want to implement it, it's left to those countries which were adopting these directives, right? The form and the choice of implementation is left to the country's wishes. But other than that, everybody will also have to follow the same article, same requirements, another thing. It's like, for security guys here, I would say that, typical ISMS is nothing but a directive to a great extent for me, because it says what is required. At the very same time, it doesn't say this is how it has to be done, right? For example, it may say that all sensitive data has to be protected using encryption technologies. Let's say, it's not the exact control requirement of ISMS, but let's assume that this is a control requirement coming out, right? So all sensitive data must be protected using encryption technologies. This is a control requirement, right? Now, why I say this is a directive is because I, as an organization, may want to encrypt my data using AES 128-bit algorithm. The other company may want to implement, let's say, a SHA-512 based algorithm. The other company may want to implement a PGP technology, right? So what technology that I should adopt and how do I implement, the method through which I implement is not explicitly said in the control. It just says have encryption. As long as I can show my auditor that I have some form of encryption in place, which is reasonable for my risk appetite, I'm all good, right? But let's say, on the other hand, if you look at PCI DSS, from a security standpoint, it goes to the extent of saying that how you should do a control implementation as well. The best example is in ISMS for access control, it says periodically access logs have to be reviewed, access, reconciliation has to happen on a periodic basis. Now, what is the periodicity? I can define 1 year, I can define 1 day, I can define 3 months, whatever it is. But if you say take the same control in PCI DSS, it will say that every quarter or every 3 months once, you must do an access reconciliation process. That's more even specific, and it tells me what form I have to implement and what method I have to implement this control. So that's the difference between a directive and a regulation. A regulation is always very specific, and it says what is expected, how you should implement it and everything. But a directive would leave that leeway to those who are implementing on how do they want to implement that requirement, right? So that's the difference between a directive and a regulation. Since the 1995 version was a directive but not a regulation, the harmonization goal was probably on the higher side when compared to Convention 109, 108. But is it 100%? Absolutely not, because of different countries implementing certain requirements in different ways. So little bit of a lack of harmonization was still there even after Directive 1995 came in. That happened in 1995, right? Then in 2000, a very important landmark in European privacy happened. So far that we've been discussing, right, from 1948 UDHR to before 2000, data protection was never a fundamental right across Europe. You remember in 1960 slide we studied, there were 3 countries: Spain, Portugal, and which one was the other?
Austria.
So only those 3 countries had data protection as a fundamental right within their constitutions. But not all the other countries had data protection as a fundamental right. With European Union being formed, the fundamental rights have been majorly defined at an EU level, not at a national level, constitutional level, right? So in 2000, this Charter of Fundamental Rights was formed across the European Union, which was like elevating what was agreed in 1953 as ECHR. They were elevating that with the Charter of Fundamental Rights. And this Charter of Fundamental Rights included, for the very first time, right to protection of personal data as one of the fundamental rights for every European, right? This is the point where everybody gets data protection as one of the fundamental rights for them. Before 2000, it was not the case, but only Charter of Fundamental Rights coming in 2000, this became a possibility. And this Charter of Fundamental Rights was again made legally binding on all member states. That important milestone was called as Treaty of Lisbon. All right. So you make it, Treaty of Lisbon is a very, very important milestone in the EU's journey on data protection. But people sometimes get asked questions in their examination on Treaty of Lisbon. What did Treaty of Lisbon achieve? Treaty of Lisbon achieved a legally binding mechanism on the Charter of Fundamental Rights across all member states of the EU. That's the answer, right? So Article 8 explicitly, in Charter of Fundamental Rights, Article 8 was the one which started speaking about protection of personal data as a fundamental right. It had 3 subclauses that's given here. So everyone has a right to protection of personal data concerning him or her. Data must be processed fairly for specified purposes on the basis of consent of the person concerned or some other legitimate basis laid by the law. Everyone has the right to access to data which has been collected concerning him or her, and the right to have it rectified. So right to access and right to rectification are are awarded as a fundamental right by the Charter of Fundamental Rights. Other rights are not awarded as a fundamental right, but later GDPR came and made that as a right available to many people. Compliance with these rules shall be subject to control by an independent authority. That means every country this led to actually this independent authority. Actually, the clause of independent authority in Article 8 of Charter of Fundamental Rights started the way, or paved the way for data protection authorities across every member state in the European Union. Like you would have heard about the Information Commissioner's Office in the UK. You would have heard about Kennel. Kennel is the counterparty of ICOs in France. You would have heard about multiple data protection authorities in Germany, like Bavaria and other places, right? So Belgian Data Protection Authority is again a very famous person. Irish DPC, Data Protection Commissioner of Ireland, who gets always roasted in the public media for their leniency towards large data companies, other stuff. They are all, the starting point for all of them is this particular clause 8.3, part of the fundamental rights, Charter of Fundamental Rights. So this is how the harmonization started to happen in 1995, and then having data protection as a fundamental right in 2000. So look at this, 2000, this Charter of Fundamental Right came in. But then this Charter of Fundamental Right was made legally binding by Treaty of Lisbon, and that Treaty of Lisbon was signed only in 2007. For 7 years, they were only contemplating to provide, how do we provide this as a legal mechanism for citizens to exercise data protection as a fundamental right. So this was signed by the EU member states on 2007 and became effective only from 2009 onwards. So Treaty of Lisbon, I'll pause here because Treaty of Lisbon is going to be, slightly a bouncer for many, and I don't want to really take Treaty of Lisbon today itself. Just digest until the Charter of Fundamental Rights. We will see Treaty of Lisbon tomorrow or on Monday, fresh. Thank you, guys. It has been a great week for me talking to all of you, and I really started to enjoy this. It gave me great motivation and a lot of questions that asked me. It made me to go back to my study rooms and pick up my books again. Thank you very much. Keep doing this. As a group, we are fantastic. Thank you very much for all of you guys. Have a safe weekend, and we will again convene next week on Monday.
Thank you,
Thanks,
Suki.
Suki.
Thank you, Suki.
Thank
Have a
you.
good
Thank
day.
you.
Thank you, Suki.
Very
Bye.
much.
Thank you, Suki. Thanks, everyone.
Suki, can I ask a doubt? Are you here?
Yes, I'm still here. Please.
Just I won't take more than 2 minutes. See, Convention 108 also required parties to take necessary steps in their legislation, and they
Correct.
gave, like, according to the principles that were laid down earlier, right?
Right.
And same, like, not same, but directive also said that this is the basic, like, a blanket boundary, and then you can follow your own approach. Directive
Yeah.
said that.
Yeah.
So, like, in both the cases, harmonization lagged. So how was directive better than, like, directive also asked required
No.
member
So
states
there's
to
a difference, right? So the difference is, Asta, the Convention 108 left that at a principle level. Okay, the principles were not even explained within it. It just had principles that needs to be followed. But the directive, on the other hand, explained that principle in a better way. And like today, GDPR has got 99 articles as a law, as a regulation. This directive had 32 articles within it, and it had details about how do you implement certain things, what is the expectation at a bare minimum, right? So that was left to interpretation in Convention 108. The expectation was not clearly set. It said this is the principle, go follow the principle. But in directive, the expectation at least was clearly made through use of articles.
Okay, and treaty also asked the member countries to implement their own legislation.
Which treaty? Treaty of Lisbon?
Yeah.
No, let's not go there. Let's
Sorry,
park.
we have not discussed yet.
Yeah.
Right. Okay.
Yeah. All right.
Oh, okay. Thank you so much, Suki.
Yeah, as a since you being a lawyer, I would recommend other guys may get bored by looking at the legal stuffs and other stuff, right? So you can actually go ahead and look at the draft. The bare language of Convention 108, Directive 1995, and all, and you can enhance your knowledge and possibly come back and also apprise us from a legal standpoint how they were different and what kind of bridging was there between Convention 108 and 1995 directive and all, which I'm not a lawyer, I clearly lack that understanding. So you can do
I
that.
will do that over the weekends. Okay.
Sure. Thank you very much, Asta.
Okay. Thanks.
Helpful.
Good night.
Okay. Anybody has a question? If not, thank you guys. I'm signing off. I gotta go. Let's catch up on Monday. Bye-bye.